Don't forget to like, subscribe and share the videos.
Digital data law. 5 key questions about your personal data answer. See, the news is related to the analysis of the recently passed the data protection law, where it will be notified in the near future and the private sectors will be given an ample amount of time to get their policy to get transisted into, so that it could be in tune with the data protection law. So what is the details about the bill? We will look into it. So under two circumstances, the data could be used. First is, if a person has given a clear consent about the usage of his data by the government or the private entities. Under such circumstances, the data could be used. Similarly, if the data used by the government or private entities is for legitimate purpose, then the data could be used. So under these two circumstances only, the data protection bill allows the entities to use the data of the particular individual. And then before the so this is for those things which are going to happen after the law has been notified. So what is the case if the data that has been collected before the enactment or the implementation of the law? So for this, the bill says that an entity should send a notice to the individuals regarding the data that has been processed by them, and the notice should contain details like the personal data which is being processed, similarly the purpose for the processing of such data, and then he should also give a consent about the processing of his own data, and then there should be a grievance mechanisms if the individual wanted to have an appeal for. So these kind of things needed to be included into the personal data protection law. And after notification, the apps needed to send a consent notice to the individual from whom the personal data has been derived or observed, and users have the right to access the personal infos. And so this is what the right to be forgotten principle is about, where a user could able to access their data which is present with the entity. It could be either government or private entity, and they could also request for the erasure of the data which the entity has, and then he could also request the correction of the data if the entities that is using a particular person's data is wrong or it contains any kind of factual or any kind of error means, then the person could able to request those entities to correct those data. And then it has 3 roadblocks. What is it is, the government could able to exempt itself as well as the any other government institutions in terms of internal security as well as friendly relationship with the other countries. And then it could also exempt the consent of the particular individuals for usage of his data for legitimate use, that is using both the public as well as private entities could process the data of the particular individual without obtaining his consent if the reason is legitimate. For example, in the case of government, if the data has been used to provide welfare to the particular individual means, then it is exempted from obtaining consent from the particular individual. And in the case of private entities, if the service given by those private entities is for legitimate purpose means, then they can consider themselves that the consent the consent is obtained, so they could use the data. And then the act creates the data protection board, where the chairperson will be appointed by the central government, and in case of any breach that has been founded by the entities in terms of the usage of the personal data, they needed to report to the data protection board, where after the reporting of the breach by the entity to the data protection board, the data protection board will investigate the case. After, if they have found that the particular entity has used the person's data other than the purpose which was intended, other than the purpose which it should be used, then it could give a penalty up to 250 crore rupees. And then any entities or a person is not happy with the decision made by the board, means he could able to appeal to the telecom dispute settlement as well as appellate tribunal. So this is what the details in relation to the data protection law is about. Okay, how the news is being related to examination is, under prelims, the news is related to Indian polity governance. Similarly, under mains, it is related to GS paper 2, statutory, regulatory and various quasi-judicial bodies. Okay, we have seen the provisions of the law and what are the important components of the law. Let's have a look into what the challenges the law has. Since it has given power to the government to exempt any kind of situation in the name of internal securities, as well as if it considers that particular situation demands the exemption because of the involvement of security related aspect and the friendly relationship with other countries, it could lead to executive discretionary. It is increasing the discretionary of the executives, which in turn could possibly lead to the surveillance state. Similarly, the technology updation will be taking at a phase way ahead than the amendment of the changes that is happening in the policy. So this is what the challenge is about. And then the cost of compliance of the data protection law is very high. Similarly, we are all talking about the digital data protection law. The consent needed to be obtained by the entities from the individuals whose data is going to be used. And there are certain majority section of the people who are unaware about the law or the protection which is being enacted for them. And then another important thing is the independence of the board is jeopardized. Why? Because the chairperson himself will be appointed by central government, and if there is any case relating to the central government means, then there will be a possible conflict of interest could be happening. So these are all the challenges the law has. Similarly, what kind of significance the data protection bill holds is, it has increased the liberty of users to retract their data or correct their data being used by the entities, and then by making the consent of the particular individual compulsory, the accountability of the entities has been ensured. Similarly, an hefty fine nearly 250 crores will be imposed on an entity if they are breaching the law. Similarly, Article 21, the right to privacy, which is the fundamental right after the autonomy case, has been safeguarded through this law. So what need to be done to further overcome those challenges are, the law as well as the technology needed to be in tune in the future, and then the independence of the board needed to be secured, and then awareness needed to be created to the mass of the people in relation to the technology as well as the protection law which is being enacted as well as which is going to be implemented very soon. So what needed to be studied is, we should know about IT Act 2000. Similarly, we should also know about the objectives and important provisions of National Cyber Security Policy 2013. Similarly, we should also know about the Puttaswamy case, and then we should also know about what is US model, China model, as well as GDPR, that is EU model in terms of regulating the datas.